Good afternoon, everyone. I want to start off by asking you all a question, or asking you to do something mentally. Everybody here knows someone who is a good storyteller. Does anyone know anyone who's not a good storyteller? You know people who are good storytellers. I want you to think of that person right now in your mind. Someone that you know now or used to know when you were growing up, a long time ago. Giving you a moment so you really do it. Think of that person in your mind. Why are you engaged with their stories? What makes you want to listen to them? They're just telling you about last weekend. They're just telling you about a vacation they took. Something happened when they were a kid. But they make it so engaging. Think about why. I bet what you're probably thinking to yourself is, well, they use good detail. They animate it. They use their voice, they use their physical positions to bring the story alive. They're making you visualize things that they're saying. So they are engaging you with their words. And the reason I like to start out with that little exercise is because it puts you in the seat of the audience for a moment. You're the one receiving the story. So if someone who is activated and engaged and animated engages you, and if visualization and images that you can form in your mind engage you, I bet you anything that same stuff will engage the jury. So whatever engages you, you can use to engage others. Essentially, a good storyteller is going to make a story human, they're going to make a story clear, and they're going to make a story active. And I'm talking at the simplest level. The people that you just thought of in your mind probably don't use a PowerPoint when telling you their stories. They probably don't provide a video accompaniment or draw a chart. And they certainly don't tell you their stories in facts and figures and spreadsheets and charts. They are telling you stories with images drawn with words and basically no visual accompaniment. And it works. This is available to all of us. And that jury that's sitting there in that box, that's waiting to be engaged, that's waiting to know what are we supposed to do. They are just coming out of their lives where they are doing this kind of thing every single day. They're watching movies, they're watching TV shows. They are engaged in various ways with their friends and listening to stories. They're doing this all the time, and so are you. So you can meet them in that spot that they already are by speaking a language that they want to hear, which is the story language, the narrative language. Now, all of those things I just said, I imagine are things you already know. You've heard before you need to humanize the story, especially from the point of view of defense. You've heard before that stories are important and that juries are going to be engaged with narrative. You've heard all these things before. And I'm not here to tell you nothing but that it's important. Of course, it is important. But what I want to look at today is why is it important? How does it work? And how do you actually do these things? So if you don't mind, I will spend this 45 minutes giving you practical tips and things that you can hopefully start using right away. All right, so we're going to talk, first of all, about how to humanize the story, something that you know about from the point of view of defense, like I say, but it is critical to making any story come alive, making that story feel like it's happening to human beings. You have a particularly difficult proposition from the point of view of defense, because so often, the client you are representing is not a single person, it is an entity. It is a whole abstraction. So the plaintiff's side has, of course, a far easier time with this. And I've worked with both sides. I've worked quite a bit with plaintiff's side, where they say, well, this happened to this particular person, and this happened to this particular couple. And they can talk about how it feels, and they can talk about what happened to those people's lives. And you don't necessarily always get that handed to you so easily like they do. So you have an abstraction that you need to humanize, which of course you know you need to do, but there are many ways to do that. You can bring in someone that represents the company and have them sit there physically in the room with them. You could maybe do that, or maybe you can't. You could do a number of things to make the company come alive, but the point is that until you do, that company is really going to be in contrast with the human beings that have been introduced from the other side. So moving to a different type of art form, okay? Not theater, not performance or movies, but just a painting. Take a look at this painting for a minute. You look at that painting, I think it's pretty clear if you ask yourself, who is the protagonist of this painting? And Grant Wood has positioned this man in the bottom part of the painting as the protagonist. It's as if he's saying to you, I want you to access this picture from the point of view of this man who's digging in his garden. If you can understand a man digging in his garden, you can identify with that somehow from your own life, you can then begin to access the rest of the picture and imagine yourself there. But without that access point of a human being, this becomes much more difficult to comprehend. Grant Wood is famous for painting pictures that celebrated Americana. They celebrated a particular era of America. So an abstraction, a lot like a corporation is an abstraction. How do you paint a picture of Americana or the values of a nation? You can't really. What you can do, though, is give them an access point that gets them into thinking that way themselves. Very, very similar to what you need to do with a case story. Always give them a human touch point so that they can access the rest of the story, which may contain lots of abstractions and lots of things that they can't necessarily relate to instantly. They will be able to if they were introduced to it first from the point of view of a person, which is what plaintiffs can do very easily. So very simply put, I want to just put this out here for a moment just to kind of set up where I'm going with this stuff today. This is obviously a very simple depiction of what a case is. The plaintiff's on one side, defense is on the other side. The plaintiff's coming in with a story, and they are going to tell that story and tell that story. Defense often comes in with defense. So instead of having another story, they have defense. You just heard that story, and we are now going to defend ourselves against that story. So on the one side, we have plaintiffs with a story which has emotional resonance. It has relatable characters. It has a narrative arc. Things that the jury is used to from television and movies and plays and novels. And the plaintiffs are also going to put in their argument, their points, their facts, and their data. Defense may, and often does, come along and say, we have logical points to refute all of those things that the plaintiffs have just said. We're going to refute the claims, and we're going to present it in a non-narrative way because we want to put the emphasis back on the issue, which of course you must do. Put the emphasis back on the issue and try to get it away from all of that land of emotional appeal. But this, in my opinion, is an imbalanced scale. Now, the picture is balanced like this for the purpose of a picture, but this really, if you think about it, to most juries is not balanced. It's much, much easier to go on the side where the story is than the side where the defense is. So I put it to you, if you want to get the issue back center, if you want to put their attention back on the issue at hand, the reason that a story can help you do that is that you have now balanced the scale. You give them an emotionally resonant story. You give them relatable characters. You give them a narrative arc. A narrative arc essentially is introducing characters who want something. Characters who want something that have an obstruction in getting it, but are trying to get somewhere. That's a narrative. A character trying to get somewhere. Character trying to do something. So positive movement. If you're giving them defense, you're giving them negative movement. People are attracted to the positive movement. So if you can balance the scale with two sides that are both human, both relatable, now we can get the attention back on what's between us, which is resolving this issue. So this is just a very simple, broad way of looking at what is a story from the point of view of defense anyway. We all know what it looks like from plaintiffs. This hopefully sets up why we would even want to look at it so carefully from the point of view of defense. So, what would one of these little talks be without some good examples? So I'm now going to give you a couple of examples. I'll tell you this. I have given these lectures all over the place, as Jody told you, and a lot of my examples have come from plaintiff's side because it's just so much swifter to just say, okay, here's a person, something happened, you know. And when I was asked to do this talk, I thought, oh, I've got to get some defense examples. So I've got some fresh, hot off the press defense examples for you. So that's my way of saying I'm going to need to read some of this more than I normally would. But listen to how these differ, okay? I'm going to give you two versions, very short little brief sort of introduction to an opening statement. And I'm going to give it to you two ways, and you just think to yourself, how do they differ? Version number one. Ladies and gentlemen, the explosion that permanently disfigured the plaintiff is tragic. We agree on that. But we're here today to resolve the dispute about whose responsibility that tragedy is. The evidence we will present will prove that the responsibility does not belong to my client, Nostalgia Products. Plaintiff claims, first, that the magic light exploded and permanently disfigured her face because it was defectively designed. It was not defectively designed, and you will hear from Mr. Gabriel Harrison, who will verify that the design met all industry standards. Plaintiff goes on to claim that the product was manufactured badly because the warnings on the lighter were inadequate. Ladies and gentlemen, you will see that the lighter has a clear warning printed on it in red. Again, you will see evidence that shows you how this design goes far beyond the safety standards for similar novelty lighters in the marketplace. Third, plaintiff claims that there were no warnings or instructions in the box containing the lighter, and that is simply not true. Every magic light that leaves the Nostalgia plant contains both printed warnings and instructions. We will introduce you to Jerry Ives and Peter O'Neill, both of whom oversee the assembly lines at Nostalgia, and they will testify that each and every magic light is personally inspected for safety before it goes on the trucks for delivery. At the end of this case, you will see that though what happened to the plaintiff is indeed tragic, fault does not lie with Nostalgia. Okay? So if they've introduced those claims, that would be a way to refute those claims quickly. Of course, there would be more detail in an opening, but you get the idea. Now, listen to how this is different, and just ask yourself, what makes this version of the same stuff different? Ladies and gentlemen, what happened to Marion Hart is exactly what Nostalgia Products strives every day to prevent. In the second act of this trial, you'll learn that Ms. Hart's magic light was fully up to Nostalgia's safety standards. We'll show you evidence that will prove that when this magic light left the Nostalgia plant, it had gone through a rigorous series of safety checks. We'll show you that the product had been compromised only after it left Nostalgia's care. I'd like to talk to you now about Rita Mercer. She started Nostalgia 25 years ago because she really likes old-fashioned novelties. But she also knew that when these products were first on the market, safety standards weren't what they are today. So she made sure every product had her personal safety approval. When Nostalgia developed the magic light, she was particularly careful. She personally oversaw the design, enlisting a team of experts to test 12 versions of the lighter until they arrived upon the safest one. You'll hear from those experts later on. She hired an independent laboratory to test the magic light before it went into mass production, and they will present their report. Then she made sure all magic lights were inspected twice, once before they're wrapped in cellophane and once after. The reason? Because she wants to make sure every box contains instructions. You'll hear from the inspectors who worked on the day that magic light was manufactured. And Rita Mercer made sure each lighter had the words, "Do not overfill," printed right on the plastic casing. She didn't have to do that. She wanted to. And she did even one more thing. After the first run of magic lights went to market with the warning in black ink, she revised the design to make sure the warning was printed in red ink for better visibility. She wanted to make sure that the lighter did what her company promises, gives people of a certain age a fun and nostalgic experience. Okay, so those are relatively short, but do you see the difference? If this was a smaller class, I would ask you, but I will just keep moving on. And you think, what made them different? What I was attempting to do with these is to present one side that is saying, here are the facts that we are going to refute. And the other one says all of that exact same stuff, but puts it in a narrative line. Instead of it being just things that are facts, it is Rita Mercer's choice. She has chosen to do this and chosen to do that, and she values this and values that, and that's why those things happened. Also, I only introduced one name, Rita Mercer. The first one introduced all of these expert names. And I think that gets very confusing if you're throwing too many sort of what I would call in theater minor characters at people too fast. They are having a very hard time tracking which ones are the important ones, which ones are less important. One name. later on we can get their names. But that is what I would look at as a clean storytelling version with characters from the defense side. All right. So if we've got characters and we've humanized the company by doing something like I just did there, which is basically to make the human being at the center of the company a flesh and blood character, in that case, this vice president who's in charge of the design, then we move on to how we're going to clarify it in words. Incidentally, you can also humanize a company by not necessarily focusing on a human being, but giving the company human qualities. It can be a company that is a scrappy upstart that has these certain values, or it can be a company with integrity that does these things for their employees. As long as you're not just listing them off and you're actually depicting that company as a human being with those values and qualities. So then, you've got your company, you've got an angle that you want to humanize, and you are working on making that come alive as a character. This second part is particularly critical. Clarity, clarity, clarity. Really, the fact of the matter is, if they don't understand what you're talking about, there is no way they can care about what you're talking about. If they don't understand what you're talking about and care about what you're talking about, they're never going to do what you want them to do. The fact really is that logic is not all that persuasive. Logic is persuasive to a point, and ultimately things do have to logically add up to be persuasive. But if you think about it, we spend a huge amount of time valuing logic over just about every other form of persuasion. And it really doesn't necessarily work. Things can be perfectly sound and logical. You can have all the best evidence in the world and still lose the case. Why? Well, I'm sure there's many answers you can come up with, but it could be that that was the only tool that was ever used. So if it is clear and they care, they just might go your direction. So let's look at how we actually clarify the sometimes very arcane and difficult language that we have to put in front of them. I'm going to start here with a little bit of a roundabout way of getting at this point, but I want you to ask yourself right now, how many triangles do you see up on that screen? You're all mentally adding them up, making many triangles happen. And then I'll ask you a different way. How many triangles are on the screen? And I'm sure many of you have already come to this conclusion. Well, look, there's actually 0 triangles on that screen, because a triangle would be 3 intersecting lines. There are no examples of 3 intersecting lines on that screen. So you can make many triangles happen in your imagination, though. You can fill in the missing information, and that's what we love to do. That's what human beings love to do, is fill in the missing information. Check it out. You still see a triangle up there in the empty space. This is how stories work. This is why I use this example. This is a sort of a visual example of how a story works. You put the details in just the right place, and the audience can see the story in their imagination. It's how theater works all the time. There's always something left out for them to participate with and add. But if you don't have the details in the right place and just sort of put them anywhere, you're not going to have the same effect. Or if you just put in every single detail that you ever thought of that you just wanted to add, and hey, I just thought I'd toss this in here, you're going to have the same problem because the story won't come alive. The idea is to arrange just the details you need in just the way you need them so that they can fill in the rest of the information in their imagination. Now you might think, I don't want them imagining things, I want to tell them the facts. Well, they can only track so many facts as it is. They're already dismissing some of those facts. They're already losing some of it. They're not grasping it all anyway. You might as well give them just the key ones so they can form the visual in their mind, and then fill in the empathy and the care that they need to make those characters come alive for themselves. Here's a word version of the same thing. Ask yourself, what's the story? And there's lots of things that you can make this story into. That's a powerful 6 words that inspires you to imagine what happened and what's going to happen. There's whole websites now devoted to the 6-word stories, so look them up because it's actually quite challenging to do. This is usually attributed to Ernest Hemingway, But I took off Ernest Hemingway on the bottom of this. I used to have that up there. People would say, oh, it must be a dark story. Something horrible happened because Hemingway wrote it. We don't really know for sure, but I think it's a great example of how few words can inspire so much story in your imagination. You can trust that. This whole thing is about speaking to the visual mind. Stories in trial, of course, in opening statements, you can't argue. So you can't tell them how to feel or what the characters are feeling or what to think or what your conclusion is. And so you'll get objected to. But I say, from a storyteller's point of view, that's bad storytelling anyway. If you're telling them how to feel and what to think and what the conclusion is, we don't want that in a play or a movie either. So it's better storytelling to leave some things out so that they draw the conclusions on their own. And let me give you an example of what I mean by this. These are much shorter now. So here's an example of one way to do this chunk of an opening, and then I'll do another version in a second. The plaintiff, Lewis Moore, claims that my clients pulled out in front of him and caused the crash that left him injured. Ladies and gentlemen, that simply isn't true. I'd like to bring you to the scene of the crash. My clients, Stephen and Sarah Carlisle, were sitting in the northbound lane, prepared to make a left-hand turn. The plaintiff was in the eastbound lane, intending to continue east. When the light turned green, my clients pulled into the intersection and made a perfectly legal left-hand turn. At that moment, the plaintiff was still traveling east at over 40 miles per hour, even though the light had turned red. A witness will testify to this fact. Lewis Moore's automobile made impact with the rear of my client's car at a direct right angle, causing himself extreme injuries. Okay, so that's one version where you just go through this didn't happen, and this did happen, and this didn't happen, and this did happen. But if you think about it, the visuals that you probably, any visuals you formed in your mind were sketchy at best. A lot of eastbound, northbound, red light, green light, what? Here's, by contrast, a different version of the same thing. Steve and Sarah Carlisle pulled up into the intersection. Steve looked over at Sarah in the passenger seat, relieved that they were going to be early for the doctor's appointment they were headed to that was right around the corner. It was a final checkup before their baby's due date. And Sarah looked healthy and happy. Now, Steve could see the light for the eastbound traffic as it turned from green to yellow to red. Then his light went green and he pulled into the intersection to turn left. It was then that he first noticed the shiny black Lexus coming straight for him. He shouted to Sarah, "He's running the light," and he reached across the street to keep her safe. But the plaintiff, Lewis Moore, had already made his choice. He was in a hurry, and he chose to beat that light, which caused him to run his black Lexus straight into the rear driver's side panel of Steve and Sarah's car. The car spun around from the impact, and Sarah screamed. Glass shattered, metal crunched, and then everything went quiet. Steve looked at Sarah, and she seemed okay. Their unborn baby would probably be fine. And they will both tell you how lucky they felt to be alive. So, I'm sure you can hear a difference in those two versions of that too. One of them is giving you characters who are thinking and feeling things. The other one is not. And these characters, of course, are my clients. And it puts you in the car, and you can see this happening and see that happening, and it takes you one little step at a time through what happened from the defense point of view. Now, I could do one more little thing with this and say, all right, ladies and gentlemen, and I'm going to do this next little thing very quickly two ways too. I could extend this story, and I could say, ladies and gentlemen, there's more to this story that they're not telling you. Lewis Moore was drunk. He was very drunk. That man was a drunk man. He was a drunk man driving a car, and he was drunk, and he'd been at a bar for 2 hours, and he was very drunk, and that's why he crashed into them. And I'm sure you're all thinking, yeah, that's maybe a little argumentative. Because I'm saying, here's the conclusion, here's the conclusion, here's the conclusion. Now, that's an exaggeration. But by contrast, I could say, ladies and gentlemen, there's more to this story that they haven't told you. Lewis Moore had been at a bar for an hour and a half before this event with the intersection. He had gotten off work an hour and a half ago, went down to the tip-top tap and poured himself a Boilermaker. That's one shot of alcohol and a beer. He downed that Boilermaker, poured himself another Boilermaker. That's another shot of alcohol and another beer. And over the next 45 minutes, he had himself 2 more beers. He then slithered off his bar stool, put his hand in his pocket, got his keys out, put them into the ignition of his Chevy truck, and pulled out onto the highway headed toward that intersection. And you're thinking, I think he might be drunk. but I never said the word drunk once. So that's a very, very simple and basic example of just drawing the picture with facts. It's a more interesting story anyway. Speaking to the visual mind. Now, as you prepare things, it's very tempting to write them down first and then try and learn what you wrote. And that what happens if you do that is sometimes things get way too complicated and not user-friendly for speech. So for example, Ms. Brown has wholly failed to allege facts that, if true, would establish that competition among the nation's journalism schools would be reduced, or that the public has been in any way injured, and this failure to allege facts that would establish an injury to competition warrants the dismissal of her restraint of trade claim. Say that 10 times fast. You could take that and break it into a couple of little chunks, much more user-friendly for oral delivery rather than read delivery, or read comprehension. Ms. Brown hasn't proved facts that would establish that competition among the nation's journalism schools would be reduced. She hasn't provided facts to establish the public has been injured. Therefore, her restraint of trade claim should be dismissed. 3 sentences rather than one long, convoluted one. On paper, it looks too simple. When it's spoken, it sounds just right. Make that translation. Here's another one, simplicity. This is not simple. An interpreter is needed if, after examining a witness, the court arrives at the conclusion that the witness is without the ability to understand and speak English at a sufficient level of proficiency to comprehend the proceedings in such a way as to assist counsel in the conduct of the case. Sound like an auctioneer. And it's comprehensible if you really sit down and listen hard, but people aren't always listening that hard. So you give it to them in a much simpler, compact way. If a witness is examined and the court concludes that the witness can't assist counsel because of a lack of English language proficiency, an interpreter is needed. Boom, simple. That little translation takes a couple minutes. Not even a couple minutes, just a little bit of time, but it's worth doing. Simplicity. This is an example of how I think that an opening or anything of length should be constructed. Give the idea in a couple of sentences. Repeat the idea in a couple of paragraphs, and then repeat all of it in the full, fleshed-out, detailed version. Don't just start with the detailed version. Give a sketch, and then a little bit more of a sketch, and then the long, complicated, detailed version. By the time you do that, they care. They've been invested. Because what you say, the order that you say it, matters a great deal. What you introduce first, what you say second, what you say third, it's not in terms of logic, but in terms of engagement. So if you think about a movie, movies are never, or pretty much never, in logical order. You're usually introduced to something very dramatic at first, and you don't really know what's going on, and then the background happens after that dramatic moment, and your brain fills it in and goes, okay, yeah, I get it now. You can do the same type of thing, but we tend to spend in professional presentation, and particularly in legal arguments, we tend to want to load up everything with the background first and then get to the part that is what the dispute is. That might make sense in a book, but when it's delivered orally and live, it doesn't work because they're already checked out by the time you get to the part that you want them to listen to. Background and history is not interesting. You can put it in later. So here's what I would say. You break up your 20 minutes, and I would never advise going much longer than 20 minutes in an opening. 5 minutes, 10 to 15 minutes, and 5 minutes. In the top part, it's get those characters out. Who are we supposed to root for? Who are we rooting against? Right away, streamlined version of the story. That's that sketch of the rose, and then a common sense principle. Before you get into too much minutia on the law, what's the common sense principle? There we are. And in 5 minutes, you can do that, and they're going, I really want to know more about this. And that's what you want after 5 minutes. Them going, I want to know more, I want to know more. So you give them more. You give them more of a detailed version of the story. You give them some background. Now you get into the details. Now you get into what the opponents have said or what they're going to say or whatever. And this is now fleshing out the middle. Be careful, it still can get too in the weeds, but now you've got them and they're interested. And the last part of it is you can say, this story is actually not over yet, folks. It sounds like it is, but it actually isn't. You, the jury, are still a part of this story. You still have control over making things right. And introduce the tools that they're going to need to make it right at the end. This is a great template that I feel really does what you need to do in court, but it does need to be taken carefully and gone through very, very methodically to make sure that you're not loading up too much unnecessary information. So now that you've got your story sort of decided on and your characters and your overall narrative arc, you got it into the beginnings of a shape. Now I'm going to talk this last segment here just about making it come to life. So one of the things that confounds people a lot when they try to take something that has to be written down first and eventually spoken is how do you make that translation from the written to the spoken? It's written, it doesn't sound right if you just read it, and it doesn't look right if you just read it either. Memorizing it is way too hard. So what do? Well, freewheel it and just kind of talk through it on some bullet points. Well, that doesn't really work either. So the in-between place is the sweet spot. I say, speak it out loud while you're working on it. Then write down what you spoke. Then go back and speak it again, trying to remember what you wrote. Now you're going to get a hybrid of what you wrote and what you're speaking. Then revise all that. Have somebody listening to you. Record it. Go, what did I say? What did I say? Incorporate your spoken language into the written. And then write all that down. And then once you do this, just repeat that about 9 times. Just keep going over and keep going over and keep going over. And every single one of you, right when I said that, go, I don't have time for that. I know you don't have time for that. But I ask you this. If the case is important, the stakes are high, you've got time. You can do it. Okay, so what I'm getting at with all this is activating the story means bringing it to life right here in front of people. So when you are, what I've been talking about so far is activating things with the words, with the story construction, and making sure that your characters have come to life in the way that you presented them in the construction of the actual narrative and the opening. But I want to bring another thing up right now, which is that the way that you talk will either work for you or work against you. And coming from the land of acting and delivery for that kind of professional acting, we work a tremendous amount on delivery of the language. So all actors work on in rehearsal is how you're going to say things. You can't actually change the words. If it's a Tennessee Williams play, you can't just say, well, I don't think Stanley would talk that way today. I'm just going to add some other language. You have to use the language that's actually given to you by the playwright. So when you're using something that you've written yourself that might have been changing quite a bit, discipline yourself to actually stick to it and not change the words around too much. You can actually just change the way that you say them. So, for example, I'm going to give you a little thing here. There's ways that you can get in your own way when you're speaking. You can start to chop up the language too much like this. Okay, so listen to how the vocal inflection actually gets in my own way. Mr. Willer had spent his life trying to make a better jet engine. He headed the team of engineers who created a marvel of 21st century technology. Okay, so that downward dropping inflection is really something that is not helping my point at all. I could also do the whole nose diving thing. Mr. Willer spent his whole life trying to make a better jet engine. He headed the team of engineers who created a marvel of 21st century technology. The design that is on trial here is his and his alone. And the next thing I'm going to say is going to do this whole thing right here and kind of bottom out down here like this. And you get into vocal fry like this. Have you ever heard people talk like this before, where it just kind of growls around like this down here? That's not good. You don't sound like you actually care when you're talking like that. Or, of course, the classic question speak. Mr. Willer has spent his life trying to make a better jet engine. He headed a team of engineers who created a marvel of 21st century technology. Okay, does that make you sound like an authority? Does that make you sound like somebody who you should really follow? I don't think so. So those kinds of things can absolutely get in your way. But I want to draw your attention to one more aspect of this while we have a little bit of time left, which is that when you are needing to embody your client as a human being, we just talked about how they need to be this vast, sort of abstraction of a corporation, needs to be human. You yourself need to come across as human, because in front of the audience, you are the jury, you are their access point to whether this company is, human or not. Now, you can really get in your own way, particularly if there is a plaintiff who could possibly be very, very sympathetic. So listen to the difference in just my vocal tone, not the words, just the vocal tone, and these two ways I'm doing this here. The plaintiff, Marion Hart, has been permanently disfigured, and that has affected her in many ways. She isn't able to work in her chosen profession. She has lost her desire to pursue many of her hobbies. And she says she feels completely unable to start any sort of romantic relationship. We agree that what happened to Miss Hart is tragic. We're here today to determine who should bear the responsibility for that tragedy. I said the words. I said I cared. I said I acknowledge all the things that happened to her. I said those things. But did it seem like I meant those things? And I think you'd say probably the answer is no. By contrast, I could actually do it this way. The plaintiff, Marion Hart, has been permanently disfigured, and that has affected her in many ways. She isn't able to work in her chosen profession. She has lost her desire to pursue many of her hobbies. And she said she feels completely unable to start any sort of romantic relationship. We agree that what happened to Ms. Hart is tragic. We're here today to determine who should bear responsibility for that tragedy. So if you see what I did is just by slowing it down, by giving the language weight and meaning and sensitivity, I've actually, hopefully, embodied what I want you to perceive this company as being, which is caring and feeling about what happened to her, but what's at issue is not how it has affected her life, but actually who is responsible. And done that with sincerity. Just thinking I need to be sincere is probably not going to do it. It's partly that, and partly what techniques do you need to make sure they feel how sincere you are. And that's the communication thing. If you feel it, doesn't necessarily mean that they are perceiving what you want them to perceive. So, to wrap up, humanize your story, clarify your story, and activate your story are the three things that I brought to you here today. You've been looking quite a bit at this one slide, and though it is a very nice slide, it seems to be the slide that we're going to end on. Do we have any questions in the couple of minutes that I have left up here? Yes.
David, this is something that you and I had discussed leading up to today's presentation, but for those of us in the audience who represent individuals such as police officers or those where the public sentiment is very negative, how do we personalize them in our defense and in our cases?
Well, okay, there's a very, this is the way that I would say to personalize anything. So in the case of that, people don't just, here's what not to do. Don't just list attributes. Don't just list like the charity work that they've done or something like that, or some good qualities that you know about them, because lists can come across as not sincere. People connect to the journey or the struggle that a character is on. That's why we like watching movies and plays. So if you can say that your police officer is striving to do this and cares about that and does these activities and these things, and the actions that this police officer has done are the result of a principle or a value that they are trying to accomplish, you stand a much better chance of people thinking, okay, that person is like me. Because that's all you really want them to do is go, there's a human that is like me that I can identify with. And we all identify with, or we can at least see our struggle and someone else's struggle. And that's usually a good starting point.
Thank you, David.
You're
fantastic.
Welcome. Okay, one more thing. Since we're kind of out of time here, if you have any other questions for me, I am absolutely open to answering them. This is a forum where it's difficult to ask a lot of questions, and you might have things on your mind. I like to talk all about this all the time. It would be up on the screen, but it isn't right now. My website is asimplemessage.com/courtroom. So I'll say it again, asimplemessage.com/courtroom. And there's a way there for you to contact me and just ask any questions that you want that we didn't cover today. I think it's a fascinating subject. How do you connect with a jury and have them have an emotional and honest response that results in an action of a verdict at the end? It's something that I have studied and worked on quite a bit, and I'm more than happy to talk about it with all of you. So thank you all very much.